Hello, everybody. Welcome to this wonderful platform of Foundation Agri classes where learning meets success. In this episode, we are going to understand completely about the course intellectual property rights in a simple, clear, and concept-based manner.
That's absolutely the plan. And intellectual property rights, or IPR, it's one of those topics that sounds complicated, but it's so fundamental.
It really is, especially for anyone in agriculture.
Oh, absolutely. It affects everything from the baby seeds you plant to the machinery in the field, even the new techniques you might develop. So our mission today really is to take this big legal structure apart piece by piece.
And pull out the key concepts everyone needs to know.
Exactly. Make it clear, make it simple.
Okay, let's jump right in then. I think for most people, when you say the word property, their mind goes to something physical, something you can touch.
Sure.
You know, a piece of land, a tractor, maybe the harvest itself. But intellectual property, IP, that's something different, isn't it? What are we really talking about when we say it's a creation of the intellect?
That's the perfect place to start. We're talking about things that are born in the human mind. It's the mental work that leads to a new idea, a new story, a brand, a design.
Oh, intangible things.
Completely intangible. IP is a creation of the intellect, and it only becomes property because the law steps in and grants a temporary monopoly over that creation to its owner.
Can you give us an example of that?
Of course. The classic one is a book. You can own the physical book. That's your physical property. You can hold it. You can sell it.
Right.
But you don't own the words inside the book, the story, the characters. That's the intellectual property, and that's protected by copyright.
A temporary monopoly on an idea. That sounds incredibly powerful. So how do our legal sources break down this universe of IP? Is it all just one big category?
Not at all. It's mainly split into two huge camps. The first one is what we call industrial property.
Industrial property.
Because this category is, it's mostly focused on commercial uses and technical innovation. So it includes things like inventions, which are protected by patents.
Okay, patents.
And brand names, which are protected by trademarks. The visual look of a product that's covered by industrial designs. And then there's the link between a product's quality and where it comes from. That's geographical indications, or GI.
And the second camp, I'm guessing that's more on the artistic side.
That's exactly right. The second camp is copyright. And copyright deals with all the literary and artistic works, novels, poems, music, films, paintings. But also, and this is critical for you, for anyone in academics,
right.
It also covers computer programs, your research papers, even technical drawings.
It's just amazing to think about the history here. The idea of protecting an idea, it feels very modern, but it goes way back, doesn't it?
It goes way back. I mean, if you want to trace the family tree of the patent system, you end up in the European Renaissance. Northern Italy is really seen as the cradle of all this.
So where did it start, specifically?
The first really systematic patent system that we have on record is the Venetian Law of 1474.
1474, wow.
I know. This law gave an exclusive right for a specific period of time to stop other people from using a new invention. The Venetians recognized that for innovation to really thrive, you had to protect it.
Venice was a hub of commerce, so that makes sense. They're incentivizing innovation to stay ahead. What about the other side of the coin, copyright?
Well, the start of the copyright system is tied to a huge technological leap. The invention of the printing press by Johannes Gutenberg around 1450.
Of course.
Once you could suddenly print books in huge numbers, the threat of someone just running off unauthorized copies of your work became very, very real. It was a threat to authors, to publishers. So you needed a system to control that reproduction.
So patents from industrial need, copyright from an information revolution. Let's go back to that core difference. If I have a new design for a tractor, that's the IP. And then I have the actual physical tractor. How do I legally separate the two?
The key word is intangibility. The intellectual property is abstract. It's the right you have over that mental creation. You can't physically touch it. And critically, for that intangible idea to get any protection, it has to be expressed in a discernible way. You can't just patent a vague thought about a better engine.
You have to write it down, draw it out.
Exactly. You have to describe the whole mechanism in a full technical specification. Physical property, on the other hand, is just about possessing and controlling the material object. You own the tractor, but you own the right to stop others from making tractors with your unique design.
That distinction is so clear now, which means intellectual property rights, IPR, That must be the legal machinery that actually enforces this whole system.
Precisely. IPR are the specific legal rights that give the creator that exclusive control. They're the tools that let the owner prevent other people from using or copying or marketing their creations for a set amount of time. It's the power that government gives you.
But why? Why does society agree to grant a monopoly? It seems like it would stifle competition. What are the big advantages of having an IPR system at all?
That really gets to the heart of the social contract behind IPR. And there are four main advantages. First, it provides exclusive rights and the chance for financial reward. That's a huge incentive for people to do the hard, expensive work of innovating.
So it's the economic motivation.
Yeah.
But what's in it for the public, besides just getting the new product at the end?
That's the second and maybe the most important point. IPR actually encourages the disclosure and sharing of information.
How so?
Well, think about it. If patents didn't exist and you invented a new fertilizer process, you would guard that secret forever.
Right, you'd never tell anyone.
But the patent system makes a deal with you. It says, tell the world exactly how your invention works. Disclose every technical detail. In exchange, we'll give you 20 years of protection. After those 20 years, that knowledge becomes public property, free for everyone to use and build upon.
That's a profound exchange. A secret for public knowledge.
It is. The third advantage is that it provides a necessary legal defense. It gives creators the tools to fight back if someone steals their idea, which makes investing in R&D a lot less risky. And finally, it helps with social and financial development. Patents, trademarks, these are valuable assets. Businesses can sell them, license them, even borrow money against them. It fuels investment.
Okay, that makes sense on a national level. But innovation is global, especially in agriculture. Seeds, tech, machinery, it all crosses borders. So we need international rules. Which brings us to this cluster of acronyms: GATE, WTO, TRIPS, and WIPO. Where do we start?
We have to start with the historical foundation, which is GATE, the General Agreement on Tariffs and Trade. GATT was created right after the Second World War out of this need to stabilize the global economy. Its main job was simple: boost international trade by cutting tariffs and getting rid of trade barriers. It was signed by 23 nations back in Geneva on 30 October 1947.
And GATT was all about physical goods, right? Trading things. When did the world decide that ideas, that intellectual property, needed to be part of that same conversation?
That was a huge shift, and it happened much later. It happened during the Uruguay round of GATT, which ran from 1986 to 1994.
The Uruguay round.
This round was a game changer. It expanded the talks way beyond just tariffs. They started talking about services, textiles, and for the first time, intellectual property. Developed nations were arguing that the lack of IP protection was a massive trade barrier itself.
Because of counterfeiting and things like that.
Exactly. Rampant counterfeiting, huge economic losses. So the result of that massive negotiation was the creation of a whole new legal framework for IPR.
And that framework led directly to the creation of the WTO. So how does the World Trade Organization fit into this picture?
The World Trade Organization, or WTO, is the direct successor to GATT. It officially kicked off on January 1st, 1995. Its headquarters are in Geneva, Switzerland. The easiest way to think about the WTO is as the global referee for the rules of trade between nations.
So what's the big advantage the WTO brought to the table that GATT didn't have?
A much stronger and more binding system for dispute settlement. It helps keep global peace by making sure trade disputes are handled constructively so they don't blow up into trade wars. It just makes the rules stable and transparent, which gives businesses, including agri-tech businesses, the confidence to operate globally.
Okay, so if the WTO is let's say, the project manager for global trade, what's the specific blueprint for intellectual property? That has to be TRIPS.
That is the perfect analogy. TRIPS is the blueprint, the agreement on trade-related aspects of intellectual property rights. It was negotiated during that Uruguay round and came into force on the exact same day as the WTO, January 1st, 1995. And it is by far the most comprehensive international agreement on IP that has ever been created.
What makes it so comprehensive? I know it covers 7 main areas.
It does. It covers copyright, trademarks, geographical indications, industrial designs, patents, layout designs for integrated circuits, and trade secrets. But the real power of TRIPS is that it forces all WTO member countries to provide a minimum level of protection across all those areas.
So TRIPS sets the global minimum standard. If you're a WTO member, you have to have patent laws that, for example, grant at least 20 years of protection.
Precisely. And the agreement has real teeth to back that up. It has 3 main features. First, the standards, which we just talked about. Second, enforcement. TRIPS requires every member to have effective domestic procedures and legal remedies for IPR enforcement. You have to have courts that can issue injunctions and award damages.
And the third?
Dispute settlement. If one member country thinks another isn't living up to its TRIPS obligations, that dispute goes straight to the powerful WTO settlement process. And that process is binding. That's what makes TRIPS so effective.
Excellent. So we have the manager of the WTO and the blueprint, TRIPS. Where does the specialist WIPO, the World Intellectual Property Organization, fit into all this?
WIPO is actually an older body, set up in 1967. It's a specialized agency of the United Nations. WIPO's role is more administrative and technical. While TRIPS sets the mandatory rules, WIPO is the organization that actually administers many of the major international IP treaties.
So it handles the day-to-day work.
Yes, and it promotes harmonization of laws, and it helps developing countries build up their own IP systems. It provides legal and technical assistance, like training new patent examiners. It even offers services to resolve private commercial disputes. It works hand in hand with the WTO to make sure the whole global system functions smoothly.
That global architecture is much clearer now. So let's zoom in on some of those specific treaties that WIPO administers, the ones that make life easier for innovators. Let's start with the Madrid Protocol. This is about marks, right?
Yes, the Madrid Protocol is all about simplifying the international registration of trademarks. It's been around since 1891, but it's been updated over the years. The genius of the system is really its centralization.
Okay, so paint me a picture. I'm a seed company, and I want to launch a new line of branded fertilizer in, say, 20 different countries. What's the headache I'm facing without the Madrid Protocol?
The headache is immense. Before Madrid, you'd have to hire 20 different lawyers in 20 different countries. You'd have to prepare 20 different applications, possibly in 20 different languages, pay 20 different sets of fees, and then try to keep track of 20 different renewal dates.
That sounds like an absolute logistical nightmare.
It was, especially for smaller companies. The Madrid Protocol it fixes that. It allows you to file a single international application to seek protection for your trademark in as many member countries as you want.
So one application, one language, one fee.
One application filed with your home country's IP office in one language, English or French, and you pay one set of fees. That single application then acts as a request for protection in all the countries you designated.
And then each country examines it on its own.
Yes. Each country looks at the request based on its own national laws, but all that initial heavy administrative work is done just once. And the international registration is valid for 10 years, and you can just keep renewing it. It's a massive saving in time, money, and complexity.
A hugely practical tool. Now let's switch gears to the more philosophical side of things with the Berne Convention. This is all about protecting authors and artists.
Yes, the Berne Convention, adopted way back in 1886, is really the foundation of all international copyright law. It's about protecting works and the rights of their authors. Books, music, films, you name it. It's what gives creators the basic control over how their work gets used.
And its strength comes from three core principles that really dictate how copyright works across borders. Let's break those down.
The first, and maybe the most fundamental, is the principle of national treatment. This simply means that a work from country A must get the exact same protection in country B as country B gives to its own national works.
So, no home field advantage.
None whatsoever. If you're an Indian academic and you write a technical paper on crop rotation, France can't discriminate against your work. It has to be treated just like a paper written by a French author.
Okay, that's crucial. What's the second principle?
The second is automatic protection. And this is a huge difference from patents. Protection under the Berne Convention is not conditional on any formalities. You don't have to register your work. You don't have to put the little E symbol on it. Protection exists automatically from the very moment the work is created and fixed in some tangible form.
I find that fascinating. For a patent, you have to be so formal, file within 12 months. But for copyright, it's just inherent in the act of creation.
The protection is inherent, yes. And that leads to the third principle, which is the independence of protection. The protection you get in a member country is independent of whether protection even exists in the work's country of origin. Even if your copyright lapses at home, it might still be protected in another country according to their laws and the convention standards.
So beyond those ground rules, what specific rights does Berne guarantee for authors?
It guarantees a set of core economic rights. These are the rights to, translate the work, to reproduce it, make copies, to perform it in public, broadcast it, and so on. These are the rights you can typically sell or license to a publisher.
But they're also moral rights.
Yes, and these are different. Moral rights are about the personal, non-financial connection between the creator and their work. They are generally considered non-transferable.
What do they include?
Two main things. The right of paternity, which is the right to be named as the author of the work, and the right of integrity, which is the right to object to any distortion or modification of the work that could harm the author's reputation. Byrne ensures these personal rights are protected internationally.
Okay, let's pivot back to something very specific and highly relevant for our agribio students, the Budapest Treaty.
The Budapest Treaty, which India signed in 2001, solves a very specific technical problem. It's about how you get a patent for an invention that involves a living biological material, specifically a microorganism.
Why do you need a whole separate treaty just for that? Can't you just write a description of the bacteria or fungus in the patent application?
You'd think so, but that's the challenge. For a patent to be valid, the written description has to be good enough that any person skilled in the art can reproduce the invention. It's a requirement called enablement.
Okay.
You can describe a chemical formula perfectly on paper, but a living microorganism. It often has unique, complex traits that you just can't fully capture in words. So a written description often isn't enough to let someone else reliably replicate it.
So if my invention is a new genetically modified bacteria for soil health, the patent examiner needs to know that this isn't just a theory. They need to be able to access the actual material.
Exactly. The Budapest Treaty solves this problem by creating a system. An inventor can deposit a sample of their microorganism with a recognized International Depository Authority, or IDEA. That single deposit then satisfies the disclosure requirement for patent applications in all the member countries.
That must simplify things immensely for biotech researchers.
Yeah.
Do we have an IDA here in India?
We do. India's first IDA is the Institute of Microbial Technology, or IM-Tech, in Chandigarh. The advantages are huge. It's simpler, it's cheaper for applicants, and it helps promote R&D because it creates a reliable way for other researchers to access these important biological materials for their own work.
If you are finding this explanation helpful, don't forget to subscribe to Foundation Agri classes for more agriculture-related informative content. We cover essential topics like this to ensure your success.
Okay, we have built that global framework. Now let's bring it right down to the national level. Let's dig into the specific laws in India that govern these different types of IP. Let's start with the big one, patents, under the Patents Act 1970.
Right. A patent in India grants an exclusive right for an invention, and that invention has to be either a product or a process that gives a new technical solution to a problem. This right is your 20-year monopoly, starting from the day you file your application.
A 20-year head start is huge. So to earn that, an inventor has to clear some pretty high legal hurdles. What are the 3 non-negotiable criteria for getting a patent in India? These are the 3 pillars of patent law everywhere, really. First, novelty. The invention must be absolutely new. It can't have been published or known to the public anywhere in the world before you filed.
Completely new. Got it.
Second, utility or industrial application. The invention has to be useful. It has to be capable of being made or used in some kind of industry, and that includes agriculture.
And the third. This is the one that's often the hardest to prove, right?
It is. It's non-obviousness, or what the law calls an inventive step. The invention cannot be obvious to a person skilled in the relevant art.
So if I'm an agricultural engineer and I combine 2 existing sprayer nozzle techniques to make a slightly better nozzle, that might not pass the test.
It might fail, yes. If a regular, competent engineer in your field could have easily come to that same solution using standard technical knowledge, then it lacks that inventive spark. It's considered obvious.
The Merck-Fosamax case is a great example of this, isn't it?
It's a perfect illustration. Merck got a patent for a weekly dosage of their osteoporosis drug, Fosamax, but the court later invalidated it. Because earlier scientific papers had already suggested that you could increase the time between doses to reduce side effects. So the court basically said that moving from a daily dose to a weekly dose was an obvious thing for a doctor or scientist to try. It was predictable. Because it was obvious, it lacked that crucial inventive step. And just like that, their 20-year monopoly was gone.
That makes the standard crystal clear. It has to be a surprising, non-predictable leap. Okay, let's move to something that our academic audience deals with every day. Research papers, technical drawings. Let's talk copyright. Under the Copyright Act, 1957.
Copyright is all about the expression of ideas in literary and artistic forms. For an Agri student, this means your textbooks, your lecture notes, any computer code you write, photos from your field experiments, and your detailed technical drawings. It protects the form of your expression, not the underlying scientific idea itself.
And how long does that protection last in India?
For most works, it lasts for the creator's entire lifetime, plus 60 years after their death. So the economic benefits can pass on to the creator's family for a good while.
We mentioned economic rights and moral rights earlier with the Berne Convention. Could you quickly recap the difference for someone about to publish their research?
Sure. Economic rights are the commercial rights, the right to make copies, sell them, perform the work. These are the rights you usually sign over to a publisher.
Okay.
Moral rights, on the other hand, stay with you, the author. The right of paternity, to be named as the author, and the right of integrity, to prevent someone from butchering your work in a way that harms your reputation. Even if you sell the economic rights, you generally keep your moral rights.
And if there's a major dispute over copyright in India, who handles that?
That's the job of the Copyright Board. It was set up in 1958. It settles disputes about who owns what rights, and it can also grant compulsory licenses for unpublished Indian works. This makes sure that important academic or cultural material can get to the public, even if the copyright holder refuses to publish it.
Now let's shift to the commercial world, to branding. Trademarks, under the Trademark Act, 1999.
A trademark is your commercial signature. It's any word, symbol, design, even a sound that's used to identify and distinguish the goods or services of one company from another. It's how your customer knows that product came from you.
And we have many types. Beyond just a simple logo, are there any particularly interesting ones?
Definitely. Beyond the standard word marks and device marks, you have things like certification marks, which guarantee a product meets a certain standard, like the ISI mark. And then you get into the really unconventional marks.
Right. Sound, smell, color. How on earth can you trademark a smell?
Well, it has to be a non-functional scent that is so distinctively tied to one product that consumers associate that smell only with that one source. For example, a unique pine scent on a brand of tires. It has nothing to do with how the tire works. These unconventional marks are all about proving that level of distinctiveness.
And how long does trademark protection last? Is it like a patent?
Not at all. A trademark registration is valid for 10 years, but it can be renewed indefinitely. As long as you're using it and renewing it, it can last forever. And infringement is taken very seriously. It's a criminal offense, and you can face imprisonment and fines.
Okay, next up is industrial designs. If a patent protects how a new plow works, what does an industrial design protect?
The industrial design protects how that new plow looks. It's all about the ornamental or aesthetic aspect of the article. Its unique shape, its pattern, the lines, the color combination. It's about eye appeal, not function, and the look must be new and original.
So even if the mechanics are standard, a beautiful design can give you a market edge. What's the law and the duration for that?
The law is the Designs Act, 2000. You get an initial protection for 10 years, and you can extend that once for another 5 years, so a maximum of 15 years. It's important because a great design adds value and drives sales.
Now, for something hugely important in agriculture, geographical indications, or GIs, why do these matter so much? This is under the GI of Goods Act of 1999.
GIs are special. A GI is not a brand owned by a single company. It's a sign used on goods, agricultural, natural, or manufactured, where the product's quality, reputation, or unique characteristic is fundamentally tied to its place of origin.
So Darjeeling tea is the classic example.
It's the perfect example. Its unique flavor comes from the soil and climate of that specific region. Or basmati rice, which gets its famous aroma and grain length from the Indo-Gangetic Plain. That quality is inseparable from the geography.
And where does a community go to register a GI?
The Geographical Indications Registry is located in Chennai.
And what's the big benefit of registering?
It's huge for the entire community of producers in that area. It gives them legal protection. It stops producers from other places from using the name and passing off a lower quality product. This helps guarantee authenticity, it boosts exports, and it allows the real producers to get a better price for their premium product.
Okay, let's quickly touch on the last two, integrated circuits and trade secrets.
Right. Integrated circuits, or ICs, are those tiny silicon chips in all our modern tech. The law here protects the complex three-dimensional layout design of those circuits. That's under the Semiconductor Integrated Circuit Layout Designs Act 2000. Protection lasts for 10 years, and the design has to be original.
And finally, trade secrets. If I have a secret formula for a seed coating that I don't want to patent, how is that protected?
That's a trade secret. It's any formula, process, or information like your seed coding recipe that gives you a competitive advantage precisely because you keep it a secret.
So what are the pros and cons compared to a patent?
Well, the advantages are big. There's no registration process, no fees, and most importantly, no time limit. It can be protected forever.
But what's the catch?
The catch is that the protection is fragile. It disappears the second the secret gets out, whether it's stolen or you accidentally reveal it. And unlike a patent, a trade secret gives you zero protection against reverse engineering. If your competitor can legally buy your product, take it apart, and figure out your secret formula, they are free to use it. A patent is a strong wall for 20 years. A trade secret can last longer, but it has no wall at all.
That's a critical distinction. Okay, we've covered the types of IP. Now let's dive deeper into the specifics of Indian patent law. I want to start with something very important for our agricultural listeners. What can you not patent in India, according to the Patents Act, 1970?
This is Section 3 of the Act, and it's so important. It reflects major public policy decisions in India. For starters, you can't patent a mere discovery of a scientific principle. The Roman effect, for instance, is a discovery, not an invention. You also can't patent a new use for a known substance. If you find out that a known fungicide also happens to boost root growth, that new use by itself is not patentable.
And what about the exclusions that are specific to agriculture and medicine?
This is absolutely vital. The law explicitly states that a method of agriculture or horticulture is not patentable.
So, to be clear, you can't get a monopoly on a new technique for planting rice.
Exactly. Or a new way of pruning grapevines, or a better schedule for tilling soil. Even if your method is new and improves yield, it has to remain in the public domain for all farmers to use freely. The same goes for any process for the medical or surgical treatment of humans, animals, or plants. The law prevents monopolies on essential processes for healing and growing.
That's a huge safeguard for public health and food security. Okay, so let's say an agri-tech company has something that is patentable, a new soil sensor, for example. Where do they start the filing process?
The head patent office is in Kolkata, with branches in Delhi, Mumbai, and Chennai. They can file the paperwork physically, but more and more it's done through e-filing, which started back in 2007.
Now, when they file, they have to submit a specification.
Yeah.
I heard there's a strategy to filing a provisional specification first. What's the point of that?
The provisional specification is your first preliminary document. It doesn't need all the final technical details, but its purpose is absolutely crucial. It secures your priority date.
For the priority date?
Yes. It's like planting a flag in the ground. From that date forward, nothing that gets published can be used to argue that your invention isn't new. You've claimed your spot in time, but, and this is a big but, you must then file a complete specification within 12 months.
And that complete specification has to lay everything out on the table.
Everything. It's the full techno-legal document. It must disclose the invention completely, including the best way to perform it. And this is the document that eventually becomes public. But the most critical part of it, the part that lawyers fight over, is the claims.
The claims. They're often called the heart of the patent.
Why? Because the claims define the exact boundary and the extent of your legal protection. Think of it like the fence around your property. If you write your claims too broadly, a court might invalidate them for covering things that were already known. If you write them too narrowly, your competitors can easily design around your patent and not infringe.
So they have to be just right.
They have to be incredibly precise. They usually start with a broad principal claim and then have narrower subordinate claims that define specific features.
Now, once an application is published, it's open for others to challenge it. Let's talk about the two stages of opposition.
Right. This allows competitors, or anyone really, to argue why a patent shouldn't be granted. The first window is pre-grant opposition. This can be filed by any person after the application is published, but before the patent is actually granted. And here's the key thing.
What's that?
There is no FE for filing a pre-grant opposition.
No fee. That's a very low barrier for someone to raise an objection.
It is. It's designed to be accessible. Now, after the patent has been officially granted, you move into post-grant opposition. This can only be filed by an interested person, someone with a commercial or legal stake in the matter. And it has to be filed within 1 year of the grant. And for this one, a fee does apply.
And if an opposition succeeds, or if a patent is challenged in court years later, it can actually be canceled. That's called revocation.
Yes, revocation is the ultimate cancellation of all rights. It to be done by the government or a high court. The common reasons are that the claims were invalid, or that the patent was stolen from the true inventor, or that the invention was already being used secretly in India before the priority date. It's the final check on a wrongly granted monopoly.
Speaking of checks on monopolies, let's talk about a powerful tool in Indian law designed to prevent misuse. Compulsory licensing, or CL. Why is this needed?
Compulsory licensing is a mechanism where the government can allow a third party to make, use, or sell a patented product without the patent holder's permission. Its purpose is all about public interest and equity. It's there to make sure that a critical invention is actually available, affordable, and being used in India.
So when can someone, say a local manufacturer, apply for CL?
They have to wait 3 years from the date the patent was granted. After that, they can apply, but they have to prove that one of 3 specific conditions is being met.
And what are those 3 conditions?
First, that the public's requirement for the patented product is not being satisfied. Maybe there are shortages of a critical pesticide, for example. Second, that the invention is not available to the public at a reasonably affordable price. This is obviously huge for medicines and agricultural inputs.
And the third?
Third, that the invention is not being worked in the territory of India. This means it's not being manufactured here and maybe not even imported in sufficient quantities to meet the country's needs.
So if a foreign company gets a patent on a vital new seed technology, but then refuses to produce it here and only sells it at a very high import price, the government can step in.
After 3 years, yes. The government can step in and grant a license to a local company to produce it. The original patent holder still gets a reasonable royalty, but the product gets to the market at an affordable price. It ensures the social contract of the patent is upheld.
Before we leave patents, let's quickly cover the Patent Cooperation Treaty, or PCT. How does this help Indian innovators who want to go global?
The PCT is a system that simplifies the filing process. It's important to note it doesn't grant a world patent. There's no such thing. Instead, it lets an applicant file a single international application in one language. That one application then acts as a national filing in all the member countries they designate.
What's the big strategic advantage of doing that?
Time. It gives the inventor a huge time buffer. You get up to 30 months from your original priority date before you have to start the really expensive process of filing in each individual country, paying for translations, hiring local lawyers. That's 2.5 years to do market research, find funding, and decide if it's worth pursuing protection in dozens of countries.
And it also gives you an early warning if your patent is weak.
Yes, a huge benefit. The PCT process includes an international search report, which tells you about any prior art that might affect your patent's chances. So you get a good idea of how strong your application is before you spend a lot of money on it.
Okay, that wraps up the standard IP types. Now we're moving into the most specialized and, frankly, the most important legal area for our audience: plant variety protection and farmers' rights. We have to start with the international standard, UPOV.
Right. UPOV is the International Union for the Protection of New Varieties of Plants. It provides the global framework for granting IP rights to plant breeders.
And our sources make a big deal about the difference between the UPOV 1978 Act and the later UPOV 1991 Act. Why is that shift so critical to understand?
Because the 1991 Act massively strengthened the rights of breeders, and in doing so, it restricted some of the traditional freedoms of farmers and researchers. The minimum protection term, for instance, was extended. It went from 15 or 18 years to 20 years for most plants and 25 years for trees and vines.
And the really big change was around something called essentially derived varieties, or EDVs.
Exactly. Under the 1978 Act, a breeder could freely use a protected variety to breed their own new variety. The 1991 Act changed that. It introduced the EDV concept. If you take a protected variety and make just one small change to it, your new variety might be considered essentially derived.
And if it is?
If it is, you need to get authorization from the owner of the original variety to commercialize it. It basically restricted the freedom to innovate using existing protected plant material.
And this international shift put a lot of pressure on countries like India, which had to comply with TRIPS but also wanted to protect its millions of traditional farmers.
That tension is exactly why India's law is so unique and so important. But before we get to the Indian law, what does any new plant variety need to show to get protection under UPOV standards? It has to pass the famous DUS test.
DUS.
DUS, distinctness. The variety has to be clearly different from any other known variety, uniformity. All the plants of that variety have to be sufficiently uniform in their key traits. And stability. The variety's characteristics have to remain stable, generation after generation.
Distinctness, uniformity, stability, DUS. Okay, now let's get to India's answer to all this. The Protection of Plant Variety and Farmers' Rights Act of 2001, the PPNFR Act.
This is a landmark piece of law. It was created to meet India's TRIPS obligations, but it deliberately chose not to follow the restrictive path of UPOV 1991. The PPVNFR Act is unique in the world because it protects the IP rights of professional plant breeders, but it also explicitly recognizes and protects the rights of farmers and researchers.
So it's a dual rights system. When did the governing body for this get set up?
The PPVNFR Authority was established on November 11, 2005, and it's headquartered in New Delhi. Its whole purpose is to encourage R&D for new seeds, while at the same time protecting the rights of the traditional farming community.
And what kinds of varieties can be registered under this act?
There are four main types: new varieties, which meet the DUS test; extant varieties, which are varieties that were already well-known or notified under the old Seed Act; farmers' varieties, which have been traditionally cultivated and developed by farmers themselves; and essentially derived varieties, or EDVs.
And what's the protection period in India?
It's 18 years for trees and vines and 15 years for all other crops and extant varieties.
Now, for the most important part of this whole discussion for our audience, let's break down the detailed farmers' rights under this act. What's the very first right it grants them?
The first is the right to registration. The Act says that farmers can register the new varieties that they themselves have bred or developed. It gives them the same legal footing as a big seed company. And second, and this is probably the most revolutionary part, is the right on seed.
This right seems like a direct countermeasure to the stricter corporate seed laws internationally. What exactly can a farmer do with the seed of a protected variety?
This right legally protects the traditional practices of Indian agriculture. It says that a farmer is fully entitled to save, use, sow, resow, exchange, share, or sell their farm produce. And that includes the seed, even if it's from a protected variety.
Wait, they can sell the seed of a protected variety? How does that not infringe on the breeder's rights?
This is where the law draws a very clever line. There's one crucial constraint. A farmer cannot sell that seed under a branded label. They can't package it or label it in a way that would trick people into thinking they are the official breeder. So they can sell their surplus grain as generic seed to a neighbor, but they can't set up a commercial seed business using the breeder's brand name. It protects tradition while also protecting the breeder's commercial investment.
That's a very elegant solution. What other rights are there?
The Act also formally recognizes the historical role of farmers. That's the third right: recognition and reward. Farmers who are involved in conserving genetic resources, the people who have maintained biodiversity for generations, are entitled to a reward from the National Gene Fund.
So it's a financial incentive for conservation.
Exactly. The fourth right is benefit sharing. If a breeder uses a farmer's traditional variety as the source material to create a new commercial variety, that farmer has a right to an equitable share of the profits.
And what about performance? What if a farmer buys seed of a protected variety and it fails?
That's the fifth right: compensation. If the seed fails to perform as promised, and it's because the breeder didn't provide the necessary information about how to grow it properly, the farmer can claim compensation from the breeder.
And finally, the Act gives farmers a kind of legal shield.
Yes, the protection against infringement. The Act says that farmers are largely protected from penalties for infringement if they can prove they didn't know they were doing anything wrong. It's a practical recognition of the reality on the ground. And researchers are also explicitly allowed to use protected varieties for research and to breed other new varieties.
The PPVNFR Act really does seem like an incredibly sophisticated piece of law, trying to balance modern R&D with thousands of years of farming tradition.
It's a true balancing act, and it's admired around the world for that reason.
That balance leads us perfectly into our final big topic: traditional knowledge and biodiversity. So let's start with the definition. What exactly is traditional knowledge, or TK?
Traditional knowledge is the accumulated wisdom, the skills, the practices that are developed and preserved within local or indigenous communities and passed down through the generations. It's a core part of their lifestyle. It can be something tangible, like a specific way to preserve grain, or intangible, like the rituals or songs associated with that practice.
And when this incredibly valuable knowledge is stolen or misused, especially by outsiders trying to get a patent, we have a term for that: biopiracy.
Biopiracy is the use of IP systems, usually patents, to claim exclusive ownership over biological resources or products that are derived from the traditional knowledge of other cultures, without giving any recognition or compensation. It's the theft of a community's heritage.
And India has had some very famous cases of this, which really shaped our laws.
Oh, yes. The most famous cases involved patents being filed overseas on things that were common knowledge here for centuries. There were attempts to patent the unique grain qualities of basmati rice, and patents sought for the medicinal antifungal properties of turmeric and neem.
And India had to fight to get those patents revoked.
We did, and we won. But those fights showed just how vulnerable this knowledge was and how urgently we needed to protect it.
So how does our legal system try to protect TK holders now?
We use a two-pronged approach: positive protection and defensive protection. Positive protection is about giving TK holders actual rights, so they can take legal action against misuse and demand compensation.
The defensive protection.
Defensive protection is about preventing other people from getting illegitimate IP rights in the first place. And our main weapon here is the Traditional Knowledge Digital Library, or TKDL.
The TKDL.
Yes. This is a massive database where we've documented traditional knowledge in a modern classified format. We share this database with international patent offices. So now, if someone in another country tries to patent a traditional use of turmeric, the patent examiner can search the TKDL, see that it's not new, and reject the application immediately. It stops biopiracy before it happens.
A brilliant defensive shield. Now let's look at the global treaty that governs all of this. The Convention on Biological Diversity, the CBD.
The CBD is the key international treaty for biodiversity, the variety of all life on Earth. It was open for signature in 1992 and came into force at the end of 1993.
And what is its single most important goal?
It has three main goals. Conservation and sustainable use are two, but the most revolutionary one is the fair and equitable sharing of benefits that come from using genetic resources. This concept, often called access and benefit sharing, or ABS, is at the heart of everything that followed.
Building on that, there's a more specific treaty for agriculture, the International Treaty on Plant Genetic Resources for Food and Agriculture, or ITPG-RFA.
The ITPG-RFA is all about recognizing the contribution of farmers and making sure everyone has access to the plant genetic resources for food and agriculture, or PGRFA. This is critical for breeding new crops that can adapt to climate change and new diseases.
And its main tool is something called the multilateral system. Why is this so innovative?
The multilateral system is a game changer. It basically puts the genetic material of 64 major food crops, the ones that make up about 80% of the food we eat, into one big global pool. This gives researchers from all member countries free access to these resources for research and breeding.
So instead of a German breeder having to negotiate with India to get a sample of a drought-resistant wheat variety, they can just access the global pool.
Exactly. It removes all that bilateral red tape. And in return for that free access, if a commercial product is developed using material from the pool, the user has to share the benefits back into a common fund that supports global conservation efforts. It keeps genetic diversity accessible for everyone's future food security.
And how does India actually implement all these CBD goals at home? How do we connect access to our resources with benefit sharing?
That is the job of the Indian Biological Diversity Act of 2002. It came into force in 2004, and its goals perfectly mirror the CBD's: conservation, sustainable use, and equitable benefit sharing.
And this act created a specific governing structure, didn't it?
It did. A three-tier structure. At the top, you have the National Biodiversity Authority, or NBA, which is headquartered in Chennai. Then you have state biodiversity boards, or SBBs. And at the grassroots level, you have biodiversity management committees, or BMCs, which are responsible for documenting local biodiversity in people's biodiversity registers.
Let's focus on that central job of the NBA, regulating access and benefit sharing, or ABS. Who needs to get approval from the NBA to access India's biological resources?
Approval is mandatory for any non-Indian, any NRI, any foreign company, or any Indian company with foreign shareholding. If they want to access Indian biological resources or the associated traditional knowledge for commercial use, research, or to apply for IPR, they must get prior approval from the NBA.
And if the NBA grants them access, what form does the benefit sharing take? How does it get back to the local communities who are the custodians of that resource?
The NBA sets legally binding conditions. The benefits have to be equitable, and they can take many forms. It could be joint ownership of any IPR that's developed. It could be monetary compensation. It could be a transfer of technology back to the local community. It could even be a requirement to set up research facilities in that area.
This whole legal structure, from the way the Patents Act is written, to the PPV-NFR Act, to the Biodiversity Act, It really shows that India has made a very deliberate choice to use IPR not just for innovation, but as a tool for equity and conservation.
It is a complete legal ecosystem. It's designed to acknowledge and reward modern intellectual creation, while at the same time safeguarding the traditional knowledge and genetic resources that are so vital for the future of our planet, and especially for agriculture.
This has been such a deep and insightful look into a topic that can seem intimidating but is just so foundational. Let's do a quick recap of the entire thing for our listeners at Foundation Agri classes.
Absolutely. We started by defining intellectual property as the intangible creation of the mind, with roots going all the way back to the Venetian Law of 1474. We then mapped out the global structure. The WTO as the referee, TRIPS as the mandatory rulebook setting minimum standards and enforcement rules, and WIPO as the administrative helper.
Right. We covered the key international treaties that make life easier. The Madrid Protocol for Trademarks, the Berne Convention guaranteeing national treatment and automatic protection for copyright, and the very specific Budapest Treaty for patenting microorganisms.
Then we brought it home to India. We detailed patents, 20 years, based on novelty, utility, and non-obviousness, and we stressed the crucial exclusion of methods of agriculture. We went through copyright, trademarks, industrial designs, and the community value of geographical indications.
We dug into the patenting process, highlighting the strategy of the provisional specification to get your priority date, the importance of the claims as your legal fence, and the powerful public safeguard of compulsory licensing.
And then, the heart of it for this audience, plant variety protection. We contrasted the international UPOV system with India's unique PPVNFR Act of 2001, which created the revolutionary farmers' rights.
And the most important takeaway from that section: a farmer's right to save, use, sow, resow, exchange, share, or sell their farm produce, including seed from a protected variety, as long as it's not sold under a branded label.
Exactly. We finished up by looking at traditional knowledge, how India fights biopiracy with tools like the TKBL, and how this all fits into the global CBD and the ITPGRFA's multilateral system for sharing the world's major food crops. We saw how the Indian Biological Diversity Act and the NBA enforce access and benefit sharing to protect our nation's genetic wealth. It really is a complete system.
This overview should serve as a complete learning and revision resource.
We certainly hope that this deep dive has given you not just the facts and the dates, but a real understanding of why these laws exist and how they actively shape the world of agriculture and innovation all around you.
Thank you for listening. Keep learning, keep growing, and don't forget to subscribe to Foundation Agri classes for more agriculture-related videos and learning resources.